All right, there, Judge Bruce Schroeder in Kenosha, Wisconsin, calling a recess after the prosecutor Thomas Binger was trying to question Drew Hernandez about why he put together the two videos that he had recorded the night of August the 25th, 2020. One of those videos taken from a body camera worn on the left side of his body, the other taken from his cell phone, which he was holding in his right hand. For more on this, let's bring in Jonathan Turley. He's a law professor at George Washington University, a Fox News contributor. I'm here with Jackie Heinrich today. Jonathan, what's your sense of what the prosecutor was trying to do there? In my layman's eye, he was trying to suggest that maybe the video had somehow been manipulated, that he wanted to show that there was some bias in the video that Hernandez had provided to the prosecution and the defense.
I think it's even more serious than that. I think what the judge was upset with, and I would have been vociferously objecting as defense counsel, is that the prosecutor seemed to cross the line again. He asked the witness, "Did you get the assistance of an attorney?" And he said, "Yeah, I supplied this evidence to an attorney." And he then said, "Well, who was the attorney?" And then when the judge asked him why he was asking that, he said, "Well, I want to know, it goes to his credibility." Well, that would suggest that somebody who simply gets legal advice is somehow less credible. Many people enlist an attorney because they want to do things right, particularly in a case that is so high profile, where passions are so high. Many people want that added protection. And so I have a feeling the judge is going to once again ask this prosecutor, why is it that you keep on crossing these lines? Earlier the prosecutor referred to the fact that Rittenhouse had remained silent after his arrest. That is a very serious violation. It could still end up in this whole case being dismissed. Mm-hmm. And now he's drilling down on a witness to suggest that because he got an attorney, that somehow goes to his credibility. That's pretty outrageous.
Jonathan, Jackie Heinrich here. As you just referred to, that judge, Bruce Schroeder, has admonished the prosecutor a number of times, twice yesterday in pretty heated exchanges, and then a little bit just now that we heard. What impact could this have on the jury if the prosecutor is seen as disrespecting the court?
Well, quite frankly, I don't see any real prosecutorial strategy here. They're showing all the control of a falling locomotive. I mean, I don't understand why they would be making some of these arguments. For example, earlier today, the prosecution objected in front of the jury to evidence being brought in by one of the witnesses involving the videos. You have to really avoid that in front of a jury because it makes them wonder, why don't you want us to see that evidence? And when the judge rules against you, which the judge did, the jury then is really quite interested in seeing this evidence that they weren't supposed to see. But then the prosecution kept on objecting after they preserved their objection, really conveying to the jury, don't look at this. I mean, that's the type of basic problems that I'm seeing here, where the prosecution seems to be flailing around in the courtroom.
Yeah, Rittenhouse is facing 6 charges in total, Jonathan. One of them is unlawful possession of a firearm, saying that at the age of 17 he was not eligible to own a long gun as he had with him that night. The prosecution is really pushing on this particular misdemeanor charge of illegal possession of a firearm. Andy McCarthy, our colleague here at Fox, has got an interesting take on that, in which he said the prosecutors know that they have no case. They need this misdemeanor to distort reality such that they'll be able to hoodwink the jury. Under Wisconsin law, if a person engages in unlawful conduct that tends to provoke others to a violent attack, the person can lose his right of self-defense, which, of course, Rittenhouse is claiming. That's why prosecutors are desperate to keep the misdemeanor gun possession count in this case. Do you believe, as Andy seems to, that the prosecution's case hinges on this idea that Rittenhouse illegally possessed a weapon at the time? And again, that's the prosecution's claim, because Wisconsin law is kind of muddy. Therefore, he is not eligible to the self-defense defense.
Well, Andy's always very insightful on these issues. Where I'm trained as a criminal defense attorney, he comes from a very long and distinguished prosecution career. I don't think that's going to work, quite frankly. There is another explanation. They'd be happy to get anything at this point. I mean, if you come out with a misdemeanor, it's still a conviction. As I noted earlier, they seem to have reduced the range of options here from a hung jury to an acquittal because of all of these prosecutorial missteps. I think they may, in fact, be quite happy to get a misdemeanor. But Andy is correct that you could use this to try to defeat the self-defense claim. The problem I have here is that I think that they are going to find it very hard to make this cat walk backwards in that courtroom. I mean, they have lost a lot of ground.
Jonathan, just pulling it back a little bit, what are the stakes for this kind of a trial? If there is a conviction, is there some risk or concern to people that Kyle Rittenhouse could become a martyr? You saw that photo. He had appeared with the Proud Boys at one point. But then also, if he's not convicted, is there potentially some sort of concern that there would be a precedent where vigilante action is not scrutinized effectively? What are your thoughts?
Well, the problem with these trials is that it's like watching different trials depending on where you get your news. Unless you're watching the trial yourself, either this trial is falling apart due to systemic errors or it's falling apart due to systemic racism. It depends on where you're getting your news. In reality, this was a difficult case to make under Wisconsin law. They have a very robust self-defense rule. And more importantly, you then followed that difficult standard by a series of prosecutorial missteps. The prosecution kept on calling witnesses that kept on exploding on the stand. And the prosecution often asked questions they didn't know the answer to, which is a real problem in a courtroom. And so with one witness, for example, the prosecutor drilled down and said, how would you know what was in this victim's mind? How would you know, basically, that he had threatening intent? And he said, well, because he said he was going to kill me. I mean, it's that type of response that is a nightmare for trial attorneys when you trigger something like that. But it happened over and over again for the prosecution.
One of the big moments yesterday, Jonathan, was when Kyle Rittenhouse broke down in the stand not long after he first got up on the stand. The prosecutor later tried to enter into evidence what he thought was contradictory evidence to Kyle Rittenhouse's emotional state, pointing out that some months after the events of August the 25th, he appeared at a place called Pudgy's Bar in Mount Pleasant, Wisconsin, wearing a T-shirt that said, free as the F word. He was there with his parents as well. Took a bunch of selfies with people, seemed to be in a celebratory mood. The judge said what happened 4 months after that incident had no bearing on the case that they were trying at the moment. The prosecution was trying to say, look, this goes to whether or not his emotional state of mind was really as we saw it in the courtroom. Try to put that contradiction out there.
Right.
Was the judge right, Jonathan, to disallow that evidence?
I think he was, because, it doesn't go to his state of mind on that day. And it is prejudicial. It essentially paints his motives on that day with what he was wearing 4 months later. The judge is trying to protect the rights of the defendant. And I've never seen a prosecution that danced on that line for so long. These are all constitutional lines. These are bright lines. You don't talk about a defendant's use of the privilege against self-incrimination, to remain silent. You don't try to paint his conduct with how he appeared months later. The judge is trying to mind that line to keep prejudicial information out. But part of the problem I think the prosecution is facing is that this jury is getting a virtual aerobic workout, having to leave that courtroom every few minutes when they keep tripping these wires. The jury clearly understands that they're being asked because the prosecution did something that the judge doesn't like. That's not going to add to your credibility.
The Rittenhouse spokesperson, David Hancock, has made some points about bias in this case. He pointed out the fact that the president, Joe Biden, as a candidate, appeared to be referring to Rittenhouse as a white supremacist. And then he had this to say about media coverage. I want to play this sound for you.
The media has been absolutely irresponsible and purely abhorrent with this entire situation. They've been parroting the same false information time after time after time. And they even do it to this day. No, he did not cross state lines with a weapon. That was known last year. Apparently, the media doesn't care to report accurate information. It's appalling.
What are your thoughts, Jonathan?
Well, there's been a lot of misinformation about this case. I think people watching the trial are quite surprised at the disconnect between what they have read and what they are hearing. But I think the most outrageous aspect of this is, in fact, President Biden's comments. When he, before any real facts were known beyond the tragedy itself, declared this individual to be a white supremacist. He did so recently again with customs agents who were accused of flogging or whipping immigrants trying to come into the country. He just stated that as a fact and said that they would have to be punished. Those are really damaging statements from a presidential candidate or the president of the United States.
Jonathan, David Hancock took on the media for its coverage of this. It was suggested early on that Rittenhouse went to Kenosha because he was out for blood. He wanted to get involved. He has denied that. And now some liberal publications are criticizing Judge Bruce Schroeder, saying essentially he's an ally of Rittenhouse because of the way that he's handling this trial and some of the rulings that he's making. What do you say?
Well, it's astonishing to me that so many people that are calling for equal justice are calling for the removal of a judge who's holding the line on basic constitutional principles. Was he supposed to allow the prosecutor to talk about a defendant's right to remain silent and to use it as incriminating, despite a long list of Supreme Court cases saying you can't do that? I mean, what these people are arguing for is that the judge should be more of an advocate for prosecution. That's not a call for due process. That's not a call for equal justice. That's a call for mob justice. You don't want a judge to be biased, and I don't think this judge has been. Now, I'm obviously a criminal defense attorney, so I agree with many of these rulings, but these are rulings that other judges have handed down in other cases. And I have to tell you, I have rarely seen a trial like this one in terms of what the prosecution has attempted to do here. I mean, this is way beyond the pale, and it may be a bit of a sign of desperation.
All right, Jonathan Turley, good to get your take on it. Stay with us throughout the afternoon if you can, because we'll be going back to the trial at some point. Appreciate you coming in.
Thank you.